And I'm not sure y'all heard me. Hey, Carson, how are you? Can't hear you. But as we get started, we'll start shortly, but wanted to welcome everyone. We're glad you're here. This is our first MPF webinar of the new year. And we have a really interesting program with a pair of very innovative managing partners. And so delighted to have Whitney Cunningham from Arizona and Carson Pearson from Utah come talk to us about what's going on in their jurisdictions and how the legal community is reacting to it, what their firms are doing as we look at reforms within the legal profession. So, gentlemen, so glad to have you with us, and thank you for sharing and for participating.
Thanks for the invitation.
Our pleasure. Uri, good to see you.
Thank you, John. Good to see you. Happy New Year.
Happy New Year to you. How are things holding up in your part of the world?
We are doing excellent. Thank you.
Excellent. People are getting vaccinated in Israel. That's good.
Yes, that's right.
And
that's right.
You may have noticed we had a little vote tabulating and voting going on here in our Peach State. And
yes, you did.
I predicted on our year-end webinar that Georgia would turn purple. And we'll see. It's a tight one, and it may take a few weeks before we get to the end of it. But
John, isn't that just a prediction that you only brought up because you were right? I mean, really, if you were wrong a week later, would we really be talking about it now?
No. Of course not. Of course not.
Okay.
But where are you today, Carson? Are you in your office, or are you at home, or on vacation somewhere?
No, I've come into the office in a bottom corner, trying to distance from everybody. So.
And I think everybody's happy to see you distancing.
Yes.
At least that's the scuttlebutt around the firm.
That's what we hear.
Whitney, we were admiring your beautiful office and that artwork behind you. Where sit you this morning, your time? Or I guess we're right noon time.
Yeah, it's noon. It's noon here, and but yeah, this is my office. We've been in the same office since 1992 in downtown Flagstaff, and we love it. It's a good place to be, Flagstaff.
I like that painting on your wall, and as we were teasing before we went live, and I was asking Whitney what the associate offices look like at the firm, and
and I said better than they deserve.
Yeah, that's exactly what you said. So let's go ahead and get started. It is the top of the hour, and we're delighted to present today's program. It's our first of the year, and I think a really important topic managing partners across the country need to be aware of, paying attention to, because I think our panelists will agree that these restructurings are the cat's out of the bag, if you will, genie's out of the bottle, and they may be coming soon to a jurisdiction near you. And this could be a game changer for the legal profession in the United States. And it's interesting, we're starting off here in Utah and Arizona with some pretty innovative change. So, gentlemen, delighted to have you with us. I'm John. I run these managing partner programs. Hopefully, we'll get back to some live programming in the new year. We'll see. But in the meantime, we're doing these virtual webinars. My partner in crime is Uri Gutfreund. Most of you know. Hi, Uri.
And hi, John. No crime.
A
lot of lawyers on the call, John. Stop with the crime jokes.
We go back and forth and banter a bit, and very conversational format. And delighted to have Carson and Whitney with us today. I'll introduce them formally in just a minute. Our programs for 2021, we can't do the live conferences. There's no guarantee, but we're going to try to pull off our leadership conference in May here in Atlanta. That's how I come to know Carson and Whitney. They participated, and we're still holding it on the calendar, and hopefully we'll be able to pull it off. And then a fall program in Chicago we do, and as well these other things. We're going to be doing these webinars now monthly on the first Wednesday. monthly on the first Wednesday. So here is our first of the 2021 year, and our next program will be in February. So stay tuned. Always looking for topics, speakers. If you have anything you want to propose to us, please let us know. We take this under advisement. We'll get through our introductions. Want to introduce our guest speakers. People love the benchmarking data, so we'll share with you some of that as we open up our conversation this afternoon. Y'all answered some questions when you registered. Panel, very interactive. We've asked Whitney to talk to us a little bit, open us up by sharing what's going on in Arizona, what's the impetus behind this, and then we'll have Carson bring us up to speed on Utah, and back and forth we'll go. We'll do some live polling, which is kind of fun and gives you all some nice benchmarking data. We'll incorporate that into the handout materials. Uri, you monitor the questions that people type in as we go. Tell them how to do that real quick.
Yeah, sure. Well, on the right side panel, you have a tab that says questions. Ask a question. Feel free to click on that, and we'll sort of keep an eye on that, and I will bring them to the event. John, we did already get one question, which is this event being recorded, and can I listen later? John?
Yes, you may. Yes, you may. It is being recorded. We'll archive it on our website along with all the other webinars we've been presenting. This is our 17th. Since Uri and I conceived this series. I know it's hard to believe, but we started off when COVID hit because we had nothing to do, and they took hold. And we've been averaging about 150 managing partners and firm leaders, and I think 2,300 when we totaled it up year end have participated in these programs. So we're going to carry forth, and do type in your questions. We get great interaction. And thanks for being with us. Our next one will be on February 3rd. Topic to be determined. If you got any good ideas, let us know. Whitney Cunningham. Whitney is the fella in the orange tie there. Thanks for getting dressed up today, Whitney. And he's the managing partner of Aspey, Watkins, and Diesel. And they're a 16-lawyer, relatively full-service firm in Flagstaff, Arizona. And Whitney served, he's a past president of the State Bar of Arizona. General counsel, so he's been in-house, and Georgetown Law School. So Whitney, so glad to have you with us. Did I leave anything out?
No, you put in more than is actually even true, I think.
Really? I took it off your website.
I'm not running for office.
I gotta file something with the State Bar of Arizona here. I think we got an ethics violation. And Carson Pearson. And Carson is the managing partner of a very innovative young law firm in the Salt Lake City region of Utah. He's the founder of Pearson Butler. But Carson's got an entrepreneurial streak as well, and has been involved in starting up a number of businesses, and love lawyers willing to innovate, law firms willing to innovate. And he's a business lawyer, transactional guy, and got his law degree at BYU in Utah. So Carson, welcome.
Thank you.
And is there anything else our participants need to know about you?
I don't think so. They probably know too much.
Google Carson Pearson. See what you come up with, everybody.
Very entertaining.
Thank you, gentlemen. When you registered, we had 125 people when I compiled all this. I think we had about 130 altogether sign up for today's program. And as is usual, we ask a couple of questions when you register. And one of the questions we posed, does your law firm own any ancillary businesses? Yes, no, a subset of the partners, and 77% say no, we stick to the practice of law. That's what we do. But 15% have ancillary businesses, often real estate holdings or maybe a title company. Ancillary businesses, most firms sticking to what they do, which is practice law. Multidisciplinary practices, that's what MDPs stands for. And we asked folks if they thought these MDPs were going to be becoming commonplace. We see them in Europe, Australia, New Zealand, Canada, and 7 out of 10 of you say, yeah, these things are coming and they will become commonplace in the foreseeable future. Uri, you would agree that MDPs are here?
Clearly, cat's out of the bag. I think why this is such a good program, John, is this is sort of the beginning, but this program is alerting the participants to what's coming down the pike. I mean, this is like it or love it or hate them, they're here. So this is going to be a great program, John.
Well, we do feel an obligation to help managing partners, keep those antenna up, look at what's going on, big picture, because things are happening. And so often lawyers are focused on the billable hour and aren't paying a whole lot of attention to the big picture and what's going on out there. So we feel an obligation to try to, help call those trends, those important trends to the attention of law firm leaders. Do you personally favor this concept of multidisciplinary practices? And look at that, gentlemen. 41% say they haven't really drawn a conclusion one way or another and might be here to learn more. 37%, yeah, I'm with this, but 1 out of 5 say, I don't like it. I don't like it. And so we'll talk about this because they are here, whether you like it or not. They're here, and they will continue to, I think, thrive, prosper, and dramatically impact the profession. Our first polling question, and then we'll get Whitney in here to get us kicked off, and we love doing the polling questions. And this one's more for Whitney and Carson to give them a sense of the firm sizes represented on today's call. So if you've been with us before, you know the drill. How big's your law firm in terms of lawyer head count? And we usually get a pretty good cross section. 5, 4. Polls are about to close. 3, 2, 1. And as is typical, we get a good smattering of firm sizes. So we got some big law, some little law, and a lot of stuff in between.
John, show the slide.
Oh, thank you for reminding me. Technology is not my strong suit, everybody, but there's our firm sizes represented.
Mm-hmm.
And that's fairly typical as to the demographics of our firms attending the program. So let me jump back in and turn things over to you, Whitney. And you brought a couple of slides to us. And why don't you tell us what's shaking in Arizona?
Thanks, John. So I think you're in control of my deck. I have just a handful of slides to present a little bit of background as to maybe how we got here. And I want to give attribution to Professor Henderson from Indiana University, who initially assembled some of this information and presented it to a task force assembled by the Supreme Court of Arizona that I was able to be part of. And so this was in January of 2019, so that's 2 years ago. But it explains kind of how we got to where we are. So if you want to flip to the next. Professor Henderson assembled quite a bit of data, but he's not the only one, of course, that's been studying this. And Hines and Laumann back in 1982 published a book entitled The Social Structure of the Bar, and found at that time in the late 1970s that about 75% of fees spent on legal services were spent on services for individuals, and about 25% was spent on corporate law. They updated that study in 2005, which is the cover on the right. And by that time, the numbers had flipped. And John, if you flip to the next screen, we've got some Bureau of Labor Statistics information here. So that by 2005, 75% of legal fees were being spent in support of corporate law, and only 25% in support of the legal needs of individuals. So, and this employment trend shown on this graph sort of explains the story. So in the 20 years ending in 2017, law firms grew at 1.5% per year, whereas in-house departments grew at 10% per year. That's where lawyers are going. That's where legal work is getting done. But what it also means is that people are being left behind. You want to flip to the next slide. This is kind of a stunning graphic, but bear in mind, it's 2 years old now.
Yes.
These are just some of the non-law firm providers of legal services, and they've been out there for a number of years, as we know. And in Maricopa County, which is the county for Phoenix, Arizona, our largest metropolitan area, the clerk of that court reported that 80%, 90% of divorce cases have a lawyer on only one side, and 80% lawyers on neither side. And as you can well imagine, I mean, that's frustrating for clients. It's frustrating for judges, and nature abhors a vacuum. And so you have a lot of legal service providers that are not regulated by the State Bar of Arizona who are trying to come in and work on the situation. And I mean, I remember the conversations from my years at the State Bar during the time when LegalZoom was receiving 8- and 9-figure venture capital tranches and not being regulated by our Supreme Court. And you know, we would debate, well, should the State Bar, you know, bring an action against them for the unauthorized practice of law? We wouldn't be able to go toe to toe with them in terms of budget. So it was a real issue. People aren't being served. You know, lawyers are busy, but we're not reaching all of the needs that the public require. And as a result, our courts were open to the concept of opening things up, bringing in capital, bringing in more entrepreneurship. And so effective January 1 of this year, we've had some significant rule changes, and I think that's what we're here to talk about today. I don't know if that was my
Whitney,
last slide or not.
You know, Whitney, when you got one more, when you shared this slide with us at our dress rehearsal Monday, and this is 2 years old, it's a subset of the alternative legal services providers that are coming at you. And all of us were just stunned, just such a powerful visual representation of what's coming at law firms. And, you know, it's not going away, folks. And we're going to have to learn to adjust and work within this and claim our places because we can't stop the tide from coming in. It's here. And here's the last slide, Whitney, that you contributed to us.
So this is a slide that was directly from Professor Henderson. I didn't alter it, but he got to the point, and ultimately our court agreed that, well, you know, as lawyers, we have hamstrung ourselves in our ability to grow to meet the legal needs that are out there. A lot of these rules, I think, were put into place originally to protect turf, but they have also the effect of limiting our ability to be entrepreneurial. So, you know, Rule 5.4 always restricted ownership of law firms to only lawyers, right? So no multidisciplinary practice, no non-lawyers at the steering wheel of providing legal services. Similarly, then with Rule 5.5, talking about who can practice and how, and then the advertising rules in the Series 7 rules. Ultimately, our court eliminated Rule 5.4. So non-lawyers may own law firms now, and there is a regulatory structure that was created around that. It's not just open water. And then similar changes in Rule 5.5, understanding that non-lawyers now may be involved in the legal service delivery chain. And then the changes in the advertising rules were adopted largely from recent recommendations of the ABA, and they accommodate things like the new media in which we deal. You know, we're still restricted in terms of personal solicitations to, you know, people, you know, friends and family and people with whom we have a relationship. But apart from that, you know, the watchword is truthfulness. As long as the information is truthful, then you can get it out there. There were a number of other changes in many rules, 1.5 fee sharing, 1.7 conflicts, even in the definitions in Rule 1.0. But this was the heart of the matter, and this is where our rules emanated from.
You know, and Whitney, I how do you personally feel about all this stuff going down as a practicing attorney, former president of the State Bar?
You know, any change is hard and easy to argue against. But when you think about some of these rules, Rule 5.4 is a perfect example. There is nothing inherently harmful about a non-lawyer being part of a law firm. And I have a personal history with this because even when I was clerking during my years at Georgetown, I worked for a 60-attorney litigation firm in DC that had an MBA hired as its manager. He ran the firm, but he was not allowed to be an owner of the firm. And that creates a dichotomy of incentives, and it's not a good way to run a business. And so I always kind of had that in the back of my head. Things like confidentiality, loyalty, things like independence of judgment. I mean, these are the core of what lawyers do. And so our court worked hard, I think, to try to make sure that those are preserved and protected. But the prophylactic rules that didn't necessarily address active harm, they took a real hard look at and in many instances moved to the side. Now, here's the other thing I'd say too. This wasn't a power grab by the big accounting firms or the big firms or the little firms. I think this was an assertion of authority by the court over the delivery of legal services, because 20 years ago, if the court was going to regulate legal services, it would regulate lawyers, and that was it. But you saw from that prior slide, legal services are coming from everywhere now. And is the court there to regulate lawyers, or is the court there to regulate the delivery of legal services? And I think in Arizona, the court made the decision that it will be the arbiter of how all that goes down. And so that's what we have.
Interesting.
Whitney,
Whitney,
when people registered, we got a number of questions that ask, as a lawyer, does it make sense for lawyers to get behind this, or does it diminish the reputation of either the firm, the industry? What say you to that?
I think for me, it boils down to something simple, which is the delivery of legal services is going to grow. It's going to be technologically driven. There will be venture capital. And so the question is simply, is that going to happen to us and around us, or do we get to be part of it?
Yeah.
And I think we just need to understand that if we want to be part of it, then we got to join it.
As when we promoted this and an announcement or two, I come from a legal marketing background, and several of my brethren reminded me, it was Bates v. State Bar of Arizona that opened up the way for lawyer advertising back in the day. And here's Arizona again on the forefront of significant change impacting the legal profession. I sometimes talk about the legal industry, and I get called out on that by some old school lawyers who, this is a profession, not a business. It's not an industry. It's a profession.
Yeah.
Yes, it's a profession. We should recognize that, but we are running businesses, and competition's coming at us, and we got to tune into it and be part of it, I think. Let me shift gears and invite Carson Pearson to join our conversation and share with us a little bit about what's going on in Utah. But before, this was a question that Carson provided that he thought would be an interesting one to kind of segue into his talk, and that is, would you fee share with an accountant or financial planner if you were allowed to, ethically? And if you would, weigh in on the best answer as it applies to you. And as the votes are coming in, Carson, I'm going to invite you to predict what you think most of our participants on today's call are going to say. I know, not fair, but not
fair. If they're
fair.
voting while we're talking. I think it's going to be relatively split. I think there's a big dichotomy in our industry on how people feel about this.
Okay. Come on, people, vote early, vote often. Even if you voted absentee, show up at the polls. Come on.
Aren't you from Georgia?
I'm originally from Florida, but I live in Georgia and have for the past 15 years. So
he's getting the voter turnout today.
I get defensive sometimes when people say, "Are you from Georgia?" It's like, no. But here's our answer to the question. And I'm surprised to see that many folks open to this. Of course, the crowd on today's call are a bit self-selecting, and I think many are here to learn more. So with that, let me turn things over to Carson. Carson?
So in Utah, very similar to Arizona, the landscape has changed, and it's not so much a discussion of if it's going to happen, but how are we going to react? A little bit different than what's occurred in Arizona. We did change the marketing rules here in the state of Utah, but Rule 5.4 and whether or not you can have a non-attorney owner, independence of judgment, things like that are now inside of what they've created, an Office of Legal Services and Innovation. And you may have heard it called to or referred as a legal sandbox. The Utah Supreme Court has already authorized 15 different entities to practice law differently and with a little bit more liberal rules than what the traditional practitioner can do. And that's going to affect every firm in our state. Eventually, it'll start to affect firms outside. They're getting 2 applications a week with new innovative ideas. Now, I don't know, can we put that slide up, John?
And Carson, yeah, I put this one in here because it's all out there, the sandbox, and here are the applications pending before the
John, move the slide. John, the slide.
Oh, I want to hide. There we go. Sorry about
There
that.
we go.
I always make that mistake. I fail to close the slide.
One of the great things, you can go to the website listed there, sandbox.utah courts. You can just Google regulatory sandbox in Utah, it'll pop right up. But they list all of the applications that they've received and have approved. And so somebody, a managing partner or anybody else, can go through and see what other firms are requesting and what approval has been given by the Utah Supreme Court. The Utah Supreme Court and the Office of Legal Innovation will then follow up, and they're going to take in data and try to make sure that there's no harm being created in the marketplace. So far, those applications have been fairly aggressive, and their approval's been consistent. We expect more approvals to be coming out later this month.
Look at Rocket Lawyer there, folks. Number 2. Rocket
Lawyer was one of the first applicants in and approved in our state. One of the largest CPA firms in our state has also been approved to hire lawyers. If you want to go there to the sample of approved applications, we've had non-lawyers approved to practice law in various situations. Venture capitalists are coming to the table and working in technology. National insurance companies are getting involved in partnering and fee splitting with law firms. It's happening on personal injury side. It's especially prevalent in the financial planning and accounting areas. But it's coming from all sides, if you will. I think Whitney mentioned, that this isn't a push from the big 4. I think down the road, the larger firms and the larger corporations will have more to deal with. Today, it's a lot more consumer oriented and, more mom and pop and small business owner that's being encroached upon from a marketing standpoint. Over time, though, you can see what could happen with a big 4. Anybody else could own a law firm. Your question at the beginning of do law firms own any other business, ancillary businesses? I wonder in 5 years how many of us will answer that we're owned by another company and we are the ancillary business. And if we're not proactive, we might find ourselves on the other end of that spectrum instead of on top of it.
Well, I think
Carson,
a lot
can
of
I
folks,
interrupt?
Let me jump
I'm
in
sorry.
here very quick. Multidisciplinary practices. We were right there at the edge of the cliff when Enron went down, and I think that unraveled a lot of it. And Sarbanes-Oxley and law firms retrenched and put up those barriers to entry, and market forces are bringing them back down again. And here we are, and that's my observation as to kind of what some of the dynamics are. Uri, jump in. You wanted to say something?
Carson, we had a couple of questions and we continue to get questions. There's this competition, and you just made the point, which everybody's worried about, which is we might be the ancillary business. How can law managing partners, our participants, And just I'm asking as an example for you, how do you see yourself as, why is the law firm the optimum controlling party? Why are you the center? And how if law firms want to be that center, what can they do to further that argument that they indeed should be the controlling center?
You know, ultimately, I feel strongly that comes down to the leadership. I mean, the people that are on this webinar and who are doing due diligence. We've been looking at this in the forefront for about 18 months. We have our application in, and we're going to be very proactive on it. The longer you wait and hope that it's not going to come, or want to see what the landscape looks like, the less opportunity you're going to have in having a say in controlling your own destiny. So we're being proactive in terms of hopefully associating with other professionals and professional services in particular. We're weighing out possibilities in terms of technology and partnerships or associations there. All of this in our state would have to be approved by the Utah Supreme Court. But again, they've shown that they're very willing and open to the innovation right now. So I anticipate more and more of that will happen.
Wow.
There's several areas that the law firm should be the driver, and the only thing that will hold us back will be our leadership.
And Carson, when you know, as we've gotten to know each other, you're young, you're entrepreneurial. I think, you know, you're looking forward. And how are most other law firms, managing partners around Utah responding to it? As enthusiastically, or more of a wait and see approach, or what?
You know, the majority of people that we've met with are in a wait and see approach, right? How is this? What's going to happen here? How does this affect confidentiality? What about the insurance carriers? Is this really going to affect my industry? And if so, when? You know, as attorneys, I think our industry is not really known for innovation. We're not known for being the most progressive, business-minded. Our jobs and our profession is set up to look at the potential issues and problems. And while that can be a tremendous strength in advising, in terms of moving forward in the disruption that is happening in the legal industry, I think that's a huge disadvantage to us. And we're going to have to break through that and be progressive on it.
So the law firms that are taking a proactive stance, how many of them are there? Do they tend to be bigger, smaller? Is there a type of firm that seems
overall,
to be...
we're a smaller marketplace in general, but I would say predominantly what you're seeing in the applications that are approved in Utah are technology driven. They're smaller practices, and they're more consumer oriented. I do believe that eventually you'll see the larger companies come in and more VC money. I know some of that is happening right now. I know that there's some discussions coming on, even with this being on the radar of some public companies. And, you know, of course, they're looking down the road, but they're aware of what's happening. Ultimately, I think for the big money to come in, more and more states will have to adopt these types of changes. And there's at least a dozen, maybe as many as 20 that are currently exploring it. They're probably where Utah and Arizona were, you know, a year to 2 years ago.
Really interesting. And the catalyst in Utah, was it coming from the courts? Was it coming from law firms? Was it coming from these alternative legal
I think that the big leader here in Utah was probably Justice Jimenez of the Utah Supreme Court. Very, very proactive on this. John Lund, who was a former president of the Utah State Bar, was very active on this, and so they were really leading out on what they called the access to justice, you know, and that doesn't necessarily mean that it's the pro bono or the low income. It's innovation. It's delivering legal services in a more affordable and efficient way, and to do that, you need innovation.
And Whitney, in Arizona, I think you were sharing with us the real catalyst. One of the catalysts was the Chief Justice of the Supreme Court, and that access to justice, sort of, with that in mind?
Yeah, so our Chief Justice at the time, Scott Bales, organized this task force, and access to justice was always an important part of, you know, what motivated him. And what I admire about these efforts is, you know, we talk about access to justice our whole careers and pro bono and the need meet legal needs, and we invariably fail. This is the first time in my career where I've seen the court actually take action to attempt to inject some type of market or technological energy to accommodate that problem. So, like I said, I think this was an assertion by the court of authority over the delivery of legal services.
And how did we get from access to justice to non-lawyer ownership of law firms? I mean,
well, Clio had done some data aggregation among the subscribers to its services and discovered that the average solo practitioner is only billing a handful of hours a day, and then spends a substantial amount of hours on marketing, and that these folks have a lot of open time. And then you look at unmet legal needs around the country, and they're just not getting connected. And so that's where, you know, some of these technological solutions are really appealing. Now, I don't sit back in our, you know, we're 15 lawyers in a town of 75,000. We're a college town, and I don't go to bed at night worrying that I'm going to get bought up by Deloitte or that it's going to open up a branch office or, you know, those kind of things. But I'll give you an example. I've got 2 partners, an associate, a paralegal, and 2 legal secretaries who are devoted to family law and divorce. But the fact of the matter is we offer one product, which is you come and you work with an attorney, probably a partner. You're going to pay a high rate, and we'll work really hard and do a good job for those folks. But what it means is we've got some cases where we probably overcharge because we only offer one product, but we have a lot of cases where we undercharge because our lawyers are just trying to get throughput, and you know, you can't slow down and focus on the more complex cases sometimes like you should. So if we can deploy what Arizona has termed a legal paraprofessional, so it's something more than a paralegal but not quite a lawyer, who can, under our rules, literally go to the superior court, represent clients, and give legal advice in the limited area of divorce. Well, now I've got a new product offering, and not only can I probably do a better job for the clients that I have in-house, but I can reach a segment of the market that I can't currently get to because we're too expensive. So as a managing partner, it just puts more products in my product offering.
and are you intending to bring on a non-lawyer equity partner anytime soon?
Yeah, in fact, we already have. We've hired an individual who is a CPA, a certified fraud examiner, a certified family law practitioner in the accounting world, with whom we've had a long relationship. So that relationship was already there, and we have a lot of trust in her. We need to supplement her education in order to meet the requirements for Arizona's legal paraprofessional. But our expectation, so we brought her on now, and we've already incorporated her. You know, she looks at our estate plans. You know, my personal practice is real estate and business and a lot of dispute. So when we have businesses fighting or you know, anything along those lines, now she can, things that I used to have to refer out, she now can address, and we can build a client, and the client, it's a good deal for the client, and it's a good deal for us. But a year from now, I'll be sending her to court in divorce cases too.
And she'll be an owner of your law firm?
No, not then. Maybe someday.
I asked, you know, what's the reaction among Utah law firms and law firm leaders, and what's the reaction among the Arizona crowd, Whitney?
I think that I think there are a lot of lawyers and firms that, like Carson suggested, are taking a wait and see or just waking up to the reality. The big firm managers that I've talked to don't have, almost to a person, told me they don't yet see this as fundamentally altering how they do business. They're really smart folks, but I personally think that's short-sighted. I know, within my own firm, I've got senior partners who are very much of the school that the practice of law is a profession, and they don't like the concept of what's coming down the pike at all. But to their credit, the next thing out of their mouths to me is, "But this is happening, isn't it?" And I say, "Yeah." And they say, "All right, what do you want to do? Let's roll up our sleeves and figure out where to take this car out and see where it can drive." And so I'm blessed to have support that way.
Beautiful.
Hey,
And Carson,
I have a question for both panelists. You're both really plugged into this around the country. Two parts to the question, which is number one, what states do you think are the closest to making some of these changes outside of your own states? And then how did your states address, if they did, those with federal practices, right? I know some on our call already are bankruptcy, immigration, securities. These are federal issues. So how is that going to be in your firm? So the states, other states, and federal practices.
Well, I can tell you that California has already been taking a close look at some of what is happening. I don't have a list of all of the states that are along the continuum, but if California goes, then I think that's going to be telling.
And California's already developed a task force on this.
There is a really good article we'll include in the handouts. Bloomberg Law wrote a couple of months ago that kind of puts out the country and the different jurisdictions where everybody's at. And clearly Utah and Arizona are at the front, but boy, a number of states are not far behind. And Carson, you want it in there too.
Florida, New York, Illinois are looking at it. Now, I don't know that everybody will adopt it or how long they'll take to look at it, but it's on the radar of a lot of bars right now and being weighed out. And I think a lot of them are seeing what happens here in Utah and Arizona as well. How does this work and how will it roll out?
So what advice might you offer a managing partner in Arkansas? It's not here. We feel pretty insulated from what's going on the coasts, and we own our little town. We have for 50 years. What advice might you offer that managing partner of a well-established law firm in a market not yet affected by this? And Carson,
keep your ears open and have a plan, because it is coming. As Whitney mentioned, there's a lot of my partners and others that overall are just not comfortable, right? This is a big change for us. One of the things I noted to some of my partners is these rule changes, we've been taught for the last 10, 20, 30 years that it was wrong to do a certain thing, for example, on the marketing rules. And all of a sudden it's okay. And we've had to go through an emotional understanding of, wait a second, this wasn't wrong. It wasn't illegal, and it wasn't immoral. It was just a rule that we had. and that's a process that we've had to kind of work through, right? And come to terms with, and that it is okay, and it's how everybody else does business in our surrounding industries. So I think somebody, in Arkansas or another state, that they need to be aware, and I would be identifying those relationships and the business plan and model that you want to be going into.
So you might be talking to some of the accounting firms, talking to some of the wealth management firms, and just
we've been proactively working on that for 18 months in our firm, including going around the country and talking and speaking with a lot of firms that have already been proactive on this, even under their existing set of rules. A lot of things can actually occur without the rule changes. The rule changes broaden it and make it easier, more innovative, and really allow a full-blown partnership to occur. But not everyone is restricted from it in their states, even as the rules sit.
And when you pick up the phone to call that managing partner of the CPA firm across town, I'm sure they're very receptive and are interested in chatting.
People have been great, yeah. And some know a little bit about what's going on, and others have had quite a surprise sitting down at lunch.
Can we have lunch anymore? Is that allowed? A virtual lunch, maybe. But yeah, get out there, folks. This is coming. It's not going away, and I think that's very good advice. Whitney, what guidance might you offer a managing partner sitting in Maine, where this isn't quite there, but
Well, I'll throw out a couple things. One is in response to a question that Yuri had mentioned earlier. So with the new legal paraprofessional we have in Arizona, their practice is limited. The Superior Court's limited to divorce, but they're allowed to practice in the limited jurisdiction courts, or our municipal and justice courts, as well as in the administrative courts. So they won't be going to federal court. Things like fee sharing with non-lawyers are state-driven ethics rules and not federal rules. So we haven't received much pushback federally yet. But here's how I would compare it, John. I appreciated being part of this group's listserv when the pandemic struck, when the PPP loans all came out. And there was a flurry of emails among managing partners. What is it? How do we do it? And if you recall, no one was saying, "Gee, is this too much of a federal budget deficit? Is it good policy? We weren't at that level, right? We're trying to manage our firm, so we were given the rules, and then we were scrambling to understand the rules and implement them to the advantage of our firms and our clients." And this is really no different than that. The rules have changed, like Carson pointed out. Things that we were told forever were one way, now are a different way. And what are lawyers good at? We're good at figuring out the rules and using them to our advantage and the advantage of our clients. And that's what we're doing, and that's what managers anywhere need to do. There's a defensive element of it. I would like our practice to grow within our small community sufficiently that we're not a good target for, insert big law firm or accounting firm name here. And then some of it is just, I think on the offensive side, on the entrepreneurial side, it's kind of fun to think about things that we now can do that we've always been prohibited from doing in the past.
Are the banks in there at all? We talk a lot about the CPA firms and maybe it's consultancies, but are the banks in there at all?
Not that I've seen yet. Carson?
I have seen on two different fronts. One is there some applications in the sandbox here that have asked to partner with credit unions in particular. And then we have seen some discussions with some financial institutions as well. I think they might be a little bit further off, but at the end of the day, anybody who's in front of a prospective client that may need legal services is a potential partner. And every entrepreneur out there that is looking to make money is going to be seeking to come into our profession. It will certainly force all of us to change the way we do business. When you mentioned the fact that, in family law, there may be areas where you don't need to have an experienced partner handling it, right? One of the things I'm hopeful that we'll see is an ability for a law firm and everything from their legal assistant to their credentialed paralegals to be able to help people more. Right now, if we're under the unauthorized practice of law and helping somebody, and yet the corporation or the company down the street is filling out forms for free with nobody legal on staff, right? And I don't think that that's serving the marketplace. So we're constricted because we are going to follow the rules. But as that opens up, we can offer a much more cost-effective resource for people. And those that are more complex and need an attorney, much like you would need a physician. But if I can go in and get have my fever diagnosed by a nurse practitioner, that might be a better option than having to see, a cardiologist.
I think the idea
not cannibalizing, because we're being told, 80% of the market right now is going unserved. So there's a huge market share that no one's getting that we can go get.
Well, and I think lawyers need to, think of themselves more as business advisors, that trusted advisor role, that counseling role, as opposed to just I do law, that's what I do. And think of yourself more of that trusted business counselor. And there's more to it than just practicing law to help your clients be
And having an incentive to be able to connect people in all directions, and opening up that, we would love to all do it just intrinsically and altruistically, but the reality is a lot of people behave where their pocketbook is. And so, being able to open that up through fee splitting or through business arrangements, hopefully will ultimately benefit the clients in getting access to good professionals who are trusted, who are vetted, and who are providing it a service at a fair rate.
Very good. And Carson, you've shared with us a little bit about some of your plans and what you're trying to build. Do you care to share here, kind of big picture, what you're up to?
Our application is pending, so I don't know how deep I want to get into it, but we're very much on the vision of forming an MDP and moving that to where the law firm ultimately becomes a piece of that business, not the business. We want to be proactive in terms of being entrepreneurial and from the ownership and the leadership, the strategic vision of that. More or less, we want to act on and not be acted upon. We don't, as Whitney mentioned, we don't want to be the target that somebody else is coming in and looking necessarily to take out, or that we're losing market share to everybody else, especially non-attorneys coming in. So we anticipate being very proactive on that front, moving more into a trusted advisor role, hopefully being able to offer different levels of service and opening up new economic options for our clients. And then also partnering with other professionals, specifically in financial planning or accounting. There's another half dozen or so that we're looking at and how we might be able to benefit one another.
Carson, that's cool. I got to think so many lawyers around town are thinking this is a threat. This is a threat. And you're looking at it, this is an opportunity.
When an industry gets disrupted, it's an opportunity. It might be an uncomfortable opportunity, but it's an opportunity.
Very, I think it's exciting. Uri, I see you kind of wanting to jump in here. What you got?
We've gotten this question, and the question is really for each of the states, and surely we can think a little bit about the firm for a moment, as Whitney advises us well, which is investors. We're talking about non-lawyer ownership. Well, can it be a very, very silent owner, i.e. an investor, like going public? I mean, how is that being addressed in each of your states? Is that allowed? Is that foreseen?
Well, in Arizona, you could have investors of any nature you might think of. It is not, like I said before, it's not open water. We have a regulatory system. And so if you want to be what we're calling ABS, an alternative business structure, then you would file an application with our court for approval. So we're a little behind Utah as far as that goes, because that all just took effect January 1, and we've got a new committee assembled to review those applications, and they'll start to be acted upon.
And is it the Supreme Court, Whitney, or we're talking about reviews and approves this stuff? Okay.
Correct.
And same thing in Utah, it's the Supreme Court that looks at these.
The Supreme Court that ultimately approves it, but they'll have a recommendation coming from the Office of Legal Services Innovation.
Love that.
So you have to remember that the fee sharing rules have changed, the non-lawyer ownership rules have changed. The idea of multidisciplinary practice is sort of here. Ownership and managerial, ownership, particularly as it concerns managerial authority, is still something with which the Supreme Court's going to be taking a very careful look at applications, as has been done in Utah. But just like Carson had pointed out, professionals with whom we have always interacted with at arm's length, now we look at as potential business partners.
Right.
And my personal practice is business and real estate and litigation, and I don't think the nature of that practice is going to change very quickly. I don't see how, you know, online technology changes business litigation, other than, you know, on the margins. But referrals to and from, yeah, that happens all the time. And then the other practice areas within my firm, personal injury or administrative practice or family law practice, I think those already are being affected by the technological options. And so, you know, there's opportunity throughout the firm and throughout our practice areas.
You know, one little thing I learned, my first boss when I was an in-house marketer in the 80s, law firm marketing, and we had a non-lawyer CEO. First, the term non-lawyer speaks volumes, just the term. But he was a CEO, empowered, and man, he made a lot of money, couldn't be an owner, but he led that firm and held lawyers accountable. And I suppose in the not too distant future, we'll have non-lawyer, non-equity partners of law firms. That's going to be a category down the road to look for. And boy, it's a fascinating conversation. Stay tuned. He was so good at, you know, trying to, you know, you get pushback from those senior lawyers. Never done that before. Who else is doing it? Blah, blah, blah. We never, you know, that's not us. Lawyers so risk averse, so conservative, and don't like change. And he would pick up the articles and circulate them among the equity partners. Wouldn't put his opinion on the article. FYI, in light of recent conversations at partner meeting, I would advise managing partners to go find those articles, start circulating them within your firm to tune people into what's going on. And that Bloomberg article I mentioned is a good one. There are many more. Show them this thing in Utah, this Legal Services Innovation Office. Wow, legal and innovation in the same sentence. So, you know, tune your people into this. Create the sense of urgency. Start now. Don't wait, you know, until it's on your doorstep and then you're in reaction mode. Now's the time to seize the day, I would think. I'm looking at the time. It's amazing how the hour flies by. Carson, anything to kind of wrap up with, and then we got a few announcements, and we'll let folks go.
No, it's an exciting time. I do think there's going to be a few speed bumps along the way that have to be figured out, especially on the ethics front and confidentiality and conflicts, and those things will have to be navigated. E&O insurance. So it's going to be an interesting year or two, probably, while some of those wrinkles get ironed out. But it's here, it's happening. So figure out when you're going to get in the water.
And Whitney, what any parting guidance you might offer managing partners with us today?
Well, I think we just found a solution to the billable hour. we may have become unshackled as we enter into these new ventures, but I agree with what Carson has said, and I would also welcome anyone that wants to talk offline. You know how to reach me, and I'm always happy to do that.
And appreciate that, Whitney. And I will circulate their phone numbers and contact information. And I think both of you all indicated a willingness to chat with anyone who wants to learn more. And so thank you for being that resource and willing to share and help managing partners tune into this issue. It's really important. Uri, anything you got for the good of the order before we move into our housekeeping announcements? And
I just have one quick question that came up a few times today, which is, have you thought about this, how this implicates your marketing as it relates to recruiting your lawyers? Your current staff, you know, have you had that sit down with your associates and said things are changing? And how are you going to have those interviews with new recruits? And how do you describe this adventure?
We've included all of our attorneys in the discussion of what these new rules are and tried to prompt people to be thinking about it. Has not affected our recruitment yet.
Okay.
Let me, there's our, the dominoes are falling, folks. And she kind of looks like Kamala Harris now that I,
yes.
I go find these
Vice
images
President.
on iStock photography. Whitney, thank you. Carson, thank you. We had a few questions. You know, folks love the polling data, and we had these set up in our year-end webinar that Uri and I did last week. And we had some fun with it, made some predictions. But these were some of the polling questions. And people, I screwed it up the way we set it up, and it should have been a click all that apply. And I set it up as a pick one answer. But I got so many people saying, hey, John, I really would like to know. So if you all would, real quick, just kind of off topic, but part of the benchmarking data we'd love to provide, where are you going to be bumping up your budgets, your investments next year? Click all that apply. And we're going to flip it around and ask you where you're going to try to trim your investments and manage expenses. We have about 45 firms in on this so far. Keep coming, everybody. And Uri, what do you think is going to be number one? Where are we going to spend money within our budgets next year? What's number one among this group?
Tech, marketing, biz dev. I mean, that's what I think. Ooh.
That would be correct. You sound really smart. And our next topic is where are you going to kind of trim it in terms of budget in 2021, and pick from the list below all that apply. And then I will ask our guest panelists to predict where they think most firms are going to be trying to rein in their expenses. Whitney, what do you think? Number one answer.
Office space can be hard to change, so I'm going to say staff.
Staff. Carson, what do you predict?
I think office space is hard to change, but that's something everybody will be looking at. The last year certainly provided a new look at that. And I hope they don't look at staff salaries.
We got about 45 firms in, and that's what they say.
Wow.
Office space and salaries. Boy, we sound like we know what we're talking about. So, yeah, firms are certainly, we're seeing it, Uri. I think anecdotally, firms talking about stepping up that investment in technology to allow for more hybrid models, virtual models, and the technology to support that, be more efficient, process oriented. And let's look at our space, and do we really need as much as we have? And it will take a little time to work out of our leases, but that's something firms are certainly looking at as they evolve and adapt to the changing times in a post-COVID world. Our guidance we've been dispensing to law firm leaders. Whitney, thank you. Carson, thank you. Here are the contact information for each of us.
John, slide, John.
Feel free to reach out. I got to put like a prod or something to make sure I do that. But here's what we got in terms of our contact information, and feel free to reach out. Gentlemen, thank you. Thank you very much. Great conversation, very interesting. We'll keep our eye on this at the Managing Partner Forum and talk more about MDPs and the evolution of the business of law. So with that, have a happy rest of the day. Happy New Year. And we'll see you soon, I hope, in person.
Take care, everyone.
Thank you.
Thank you.
Bye, everybody. Have a good afternoon.
Thank you, Uri.
Thank you,
Whitney,
guys.
It was a pleasure to meet you, and I've appreciated all your information and insights.
You too, Carson. I look forward to maybe seeing you in Atlanta soon.
Yes.
Hopefully so. We were very disappointed last year.
Yeah, we were too.
Yes.
Yuri, take care.
Take care, guys.
Bye, everybody.
Bye.